Welcome back and thanks for staying with ANN7 Prime. My name is Cindy Mabi. Now, former Eskom CEO Brian Molefe is testifying in Parliament, and we cross live to that event.
That I will be required to enter into a fixed-term contract of employment, which is page 52 to 54. I note that when Ms. Daniels was giving evidence here, my employment contract documents for her start with this letter and not with the letter of the minister of the 2nd of October, which is a very, very big omission in my opinion. On the pension fund as well was misled by this letter of the 9th of November, which simply forgot that I had already been employed on the 2nd of October by the minister on an open-ended contract, and I was a member, therefore, of the pension fund. On the 25th of November 2015, Dr. Ngubane wrote a letter to Minister Brown. And this letter I have attached on page 55 and 56. In that letter, he requested that at the end of the 5-year contract, I be allowed to retire from service as if I'm 63 years old. Penalties prescribed by the EPPF be waived, and Eskom would carry the cost of the penalties. The letter of 25 November 2015 from Dr. Ngubane, which, by the way, had been written because I had asked members of the board and the PNG, when you change my contract from a permanent employment contract to a 5-year contract, what will happen to my pension? I asked that question because I had just come back from a 4-year stint at Transnet. My contract of employment at Transnet had actually been renewed for a further 5 years, which means that I would finish 10 years at Transnet. But now I was sent to Eskom. I was requested to go and assist at Eskom because of load shedding. And so I asked, what will happen to my pension? And then there was a presentation by the specialist at Eskom to the board and the PNG to say that we will recommend that when you leave, we pay your additional pension to make up for your agreeing to change your contract from permanent to 5 years. That is what happened, sir. Sorry, Chairperson. The letter of the 25th of November 2015, which specified these new pension arrangements, was sent by the Eskom Company Secretary, Ms. Suzanne Daniels, to Ms. Kim Davids, the Minister's PA, Osila Rathman, and Z. Mbilasi at the Department of Public Enterprises. The letter was emailed at 20 hours 33 on the 25th of November 2015 by Ms. Daniels, and the proof of that is on page 57 of the documents. At 21:05 on the 25th of November 2015, Ms. K. Davids acknowledged receipt of the letter and undertook to bring the letter to the minister's attention. And this acknowledgement is on page 57 of these documents. On the 26th of November 2015, K. Mhlongo sent an email to Ms. S. Daniels confirming that the letter will be brought to the minister's attention, and that is on page 59. Also, Osila Radman noted the letter, and her email is on page 60 of these documents. On the 9th of February 2016, the People and Governance Subcommittee of the Eskom Board, PNG, received a presentation from Mr. A. Minar. Now, please note, sir, Chairperson, that by this time, the letter about my pension arrangements had been with the department since November, and there had been no response. There's a section in the PFMA, I think it's section 54, which says if the executive authority does not respond within 30 days, approval has been granted. So I don't know. I think I cannot speak for the PNG or the board, but maybe they labored under the presumption that they have given the minister this information, and in fact, that letter requested approval for my pension arrangements, but there had not been a response from the department. So the People and Governance Subcommittee of Eskom received a presentation from Mr. Anton Minar on the 9th of February 2016, where he reported that a 5-year contract, the presentation and the minutes of the meeting of that date are attached as page 62 of the documents. He reported that the 5-year contract for the Group Chief Executive of Eskom is a first for Eskom. And I think Ms. Venetta Tlane was at pains to say that threw them in a spin during testimony this morning. He also referred to previous precedents at Eskom, where additional pensionable service was granted to executives and penalties were waived. Incidentally, when the EPPF was here, they also confirmed that this had been done before. And Mr. Brian Dames, in his evidence here, also said, my last request as he was leaving Eskom was, just like the other previous chief executives had received the patches of their years and so on, he also requested it. I don't know if it was granted, but he did say in his evidence that he also made that request. Incidentally, it would be interesting to see how far back this practice goes and which chief executives were paid in this manner or had their pensions arrangements in this manner. During the court hearings that are now going to the High Court next week, during the process, we have requested through Section 35 of the Rules of the Court from Eskom and the Pension Fund information about who else received this kind of arrangement. And both Eskom and the Pension Fund refused to tell us or to put it on record at court that these are the chief executives who received these similar benefits when they left. So perhaps this committee can shed more light on that issue by the time the inquiry is finished as to which chief executives and how far back does it go that similar arrangements were made. By the way, because the pension fund is a defined benefit fund, the benefits are defined. So it is, one has to, the contributions are really not an issue, but it's the benefits that, that are defined by defined benefit fund. During this meeting, the PNG made a resolution, which is attached on page 63, that the Eskom, the resolution I've attached on page 63 of the documents, the Eskom pension fund rules that employees may proceed on retirement from age 50 with 10 years service remains applicable. This was the resolution of the EPPF. And it also said, where executive directors, not specifically the group chief executive of Eskom, but where executive directors on fixed-term contracts take early retirement, and there is a shortfall regarding 10 years, the 10 years, Eskom will bridge the gap, waive penalties, and refund EPPF costs. This resolution was taken by at the meeting of the PNG. I note that Mr. Brian Dames testified recently before this committee that there was a practice at Eskom to permit executives to take early retirement from Eskom. Mr. Sibusiso Luthuli, Principal Officer of the EPPF, said that Pension Fund Rule 28 permitted normal retirement from the fund at age 50 with the permission of the employer. If I can read you that part of the rule. The rule. On page 80 of the page 84, section 28.3 says that no, it's on the page 80 of the.
Ignore that they must they must direct their queries to me, so that you don't get distracted.
Page 84 of the documents that I have submitted. Subsection 3 says, with effect from 4 March 2000, if a member who has attained the age of 50 years or who had attained the age of 45 years and who is listed in Appendix 10 of the rules and has not less than 10 years pensionable service becomes entitled to a benefit in terms of this rule, he may instead be granted at the discretion of the board after consulting the employer as from the date of his leaving the service of his employer, a pension in respect of his pensionable service calculated in terms of Rule 22 without reduction in terms of Rule 24. This is the rule that actually led to a lot of confusion, because in fact, if you go back to just before you get to section 28, it actually talks about retrenchments. So this rule is interpreted, in fact, to mean that it would only apply in the case of retrenchments. However, when you go to the members' guidelines, the members' guidelines simply took that rule and put it in the guidelines as if it is permissible for a member who is over 50 years old and who has the permission of the employer to go on early retirement. And the members' guidelines under section 3.3, page 68 of the documents, says a member between the ages of 50 and 63 may go on early retirement without penalty and without potential service by mutual agreement with the employer, where the employer will pay for the cost of early retirement. That is the penalty. Members between the ages of 50 and 55 need to have contributed to the fund for a minimum of 10 years in order to qualify for this benefit, which means that if the employer agreed, the employer could also pay in the 10 years, which is in fact what happened, that Eskom paid in the 10 years in terms of the guidelines. But later on, we discovered that this was in fact not so. Strictly speaking, in terms of, we even disagreed with the pension fund. We had made a mistake. We could not apply this rule in my case, and that is the subject of the court case. The guide informed my understanding of the EPPF rules and was referred to by Mr. Minar in the PNG subcommittee referred to above. On the 11th of November 2015, I wrote a letter to Dr. Ngubane requesting early retirement in terms of the rules of the EPPF and the resolution of the PNG meeting of the 9th of February 2016. Chairperson, you'll notice that I wrote a letter requesting early retirement. I did not write a letter that says, I hereby resign. I wrote a letter requesting early retirement. That letter that I wrote on the 11th of November 2015 is attached as on page 85 of the documents, the actual letter that I wrote. On the 24th of November 2016, I received a letter from Dr. Ngubane communicating the Eskom board's acceptance of my early retirement. That is attached on page 86. On the 18th of February 2017, I received a letter from the Eskom Pension Fund welcoming me as a pensioner and providing details of my pension, which is attached on page 88. In fact, if you read that letter, you will see that I did not receive 30 million rand. So, I did not receive 30.1 million rand as has been widely reported. I received a lump sum of some 7.7 million from the EPPF on being admitted to the fund. Of this, 4.3 million had been transferred by me from the Transnet Pension Fund to the EPPF when I joined the EPPF. In April 2015, after I had accepted appointment as a member of the National Assembly by the Northwest Province of the ANC, members of the Eskom board and company secretary met with me and intimated that the acceptance of my early retirement application was a mistake. I asked them to make a proposal on a way forward that would get the Minister of Public Enterprises approval. On the 11th of May 2017, I received a letter from Dr. Ngubane requesting me to resume duties as Eskom Group Chief Executive. That letter is attached, page 90 to 91 of the documents. Because of the common error of implementing the early retirement, the legal position was that the situation had to be restored to status quo ante. I obtained legal advice which confirmed that that was indeed the legal position. I signed a reinstatement agreement, which is on page 92. The reinstatement agreement did not seek to reinstate me. The fact that my pension arrangements or my pension agreement was void ab initio means that my contract of employment was still in existence, and that is what the legal advice that we obtained. And so the reinstatement agreement just regulated the manner in which I would return to Eskom on the date that had been specified by the chairman of the board. Eskom also assured me that the minister was comfortable and had approved this arrangement of the rectifying of the common mistake. Ms. Daniels, in her testimony to this committee, indicated that such approval from the minister had been obtained, page 90 to 91 of the documents that I have attached. On the 15th of May 2017, I resumed duties as Eskom Group Chief Executive in terms of my earlier contract of employment. On the 17th of May 2017, the Eskom Group Company Secretary wrote a letter to the Principal Officer of the Eskom Pension Fund advising him of my resumption of duties at Eskom with effect from the 15th of May 2017, and further advising that my membership of the pension fund must be reinstated. That letter is attached, it's page 96 of the documents. On the 15th of May 2015, the Democratic Alliance launched an urgent High Court application to challenge my resumption of duties. This was followed by an application by the EFF. The matter was originally set down to be heard on the 2nd of June 2017. I have submitted all the documents, all the affidavits, all the court records relating to this matter of the DA and the EFF, as well as which was later joined by Solidarity. All the documents have been submitted, were in this suitcase that I brought with me. On the 31st of May 2017, Minister Brown sent a letter to Dr. Ngubane instructing the board to rescind the decision to reinstate me as Group Chief Executive. An interesting thing about this decision to rescind the decision to reinstate me was that in that agreement that regulated how I would come back, I had agreed that because of the common mistake, the money that is due to the pension fund must be paid back, and I agreed to pay the money back by November this year. But now the agreement has been unilaterally rescinded, and so I don't know where the issue of the paying back of the pension money is, because I had agreed that, okay, the mistake was made, I would resume duties and I would pay back what had been paid by the pension fund, which was not 30 million, by the way. It was the 7 million, which included the 4 million that I had contributed, as well as pension payments for the month of January, February, March, and I think April. And this whole matter of how much I owe the pension fund and what the way forward is will now be determined in the High Court. We're going there next week on the 29th to the 1st, and I presume that after that we will go back to the Labour Court. On the 24th of May 2017, Solidarity launched an urgent High Court application seeking to review various decisions concerning my resumption of duties and related relief. On the 2nd of June 2017, after a brief Eskom board meeting, I received a letter from Dr. Ngubane advising me of the minister's instruction to rescind the reinstatement. This letter is attached as page 99 of the documents. On the 5th of June 2017, I launched a Labour Court application to set the summary dismissal aside. On the 6th of June 2017, the High Court application was postponed pending the outcome of the Labour Court application by the DA and the EFF. On the 4th of July 2017, the Labour Court issued an order postponing hearing my application until after judgment in the High Court applications brought by the DA and the EFF had been finalized. This was a very interesting judgment because I had been an applicant in the Labour Court matter, but the judge referred me to a matter in which I was a respondent and said that matter must be finalized first before she would hear me. It was very surprising, but nevertheless, we then went back to the High Court, and the High Court will hear the applications from the 29th to the 1st of December 2012. The Public Protector's report. The Public Protector released a report titled State of Capture Report dated 14th October 2016. The report contained a series of observations and did not make any findings. Paragraph 5.96 to 5.101 deal with my phone records and makes some notes. I have repeatedly heard, I think, Mr. Swart in these proceedings talking about findings. Although the Public Protector makes the notes, she did not ask me for my side of the story as regards the phone calls, nor did she bring the phone records in her possession to my attention before she finalized the report. An important principle of our Constitution is the right to be heard. This was denied to me by the Public Protector. She did not hear me at all on the matter of the phone calls. Secondly, the Public Protectors Act requires her to inform whoever may be implicated by the evidence that she has of the evidence and to ask them for their side of the report. She did not do so, and therefore I have not had an opportunity to ask her or to talk to her about those phone records. Significantly, however, the Public Protector's report did not make any findings as regards her notes or observations relating to my phone records. And we have toed and froed, and I think Ms. Klein referred to this earlier in her testimony and said that because there were no findings, we could not ask for a review. There were no findings about my phone records. And so the questions that the lawyers asked was, but when you ask for a review, what are you asking to be reviewed? Just a note or an observation by the Public Protector, which does not carry, I was told, any weight at all until it is converted into a finding. In fact, in the Public Protector's report, Advocate Madonsela said these matters need to be investigated further. And we were hoping that the the public protector would continue with the investigation, but perhaps her feeling was that the public protector's office was coming to an end with her term. Nevertheless, paragraphs 5.97 refers to contact between myself and Mr. A.J. Gupta on a number of occasions. The public protector fails to provide any other details about the phone calls. She does not provide the phone numbers, nor the dates and times when the phone calls were made. It is therefore difficult for me to determine the veracity of her claim in paragraph 5.97 of the report. Similarly, paragraph 5.98, there are no details of the phone numbers or the dates and times of the phone calls. I can therefore not confirm or deny the veracity of the claims. In paragraph 5.100, the public protector says I can be placed in the section world area 19 times. That is all that is said. She does not provide context or even suggest what I may have been doing there. What I understand from inquiries made to a communication expert is that any user of a cell phone within the area of a coverage of a cell phone tower, for example, Linwood, will be recorded as being in the area of, say, Linwood. This includes a user who is in transit through the coverage area of that tower. But more importantly, paragraph 5.99. I don't know if, Madam Chair, you have the Public Protector's report. Paragraph 5.99, if you go to it, it's a graph that shows the number of times that I was in the section world area. You will need a magnifying glass to read that, because I struggled with that graph for many months until I could understand it. But entry number 1 to number 10, which is 10 visits to the section world area, happened in a period of 20 minutes. If you get a magnifying glass, I have one. I carry one with me just to read this report whenever I can. I don't know where it is now. The magnifying glass. Yes, Mr. Eberhard. Prof. The public protector says I was there. The 599 suggests the number of instances that I was perpetually in the section world area only shows that I was there 5 times and not 19 times. On the 5th of August, when according to the cell phone service provider's records, I was in the area between 09 hours 17 and 09 hours 41 and made 1 phone call and received 9 others. Incidentally, when I viewed my records, about 4 minutes before and about 5 minutes after I had made the last and the first phone call, I was in fact outside of Section World, which means I did not stop for a meeting. For 20 minutes, I received 9 phone calls and made 1 phone call, and the public protector reported that I had been to Section World 10 times. The 17th of August, when according to cell phone service providers' records, I made 2 phone calls while I was in transit in the area. The 18th of August, when according to cell phone service providers' records, I made 1 phone call while I was in transit in the area. 23rd of August, when according to cell phone service providers' records, I listened to my voice messages while in transit in the area. And on the 28th of August, when according to cell phone service providers' records, I received 2 calls, listened to my voice messages, and received 1 call while in transit in the area. Paragraph 5.101 says that I had contact with Mr. Atul Gupta. This is not true, because the phone call from Mr. Atul Gupta to myself was forwarded to my message box. There is no other record in my phone records that shows that I returned Mr. Atul Gupta's call or that he ever tried to contact me again. The public protector recorded it as contact with Mr. Atul Gupta. This is according to my cellular phone records, which I have thoroughly examined since the release of a report. I would have raised These and other discrepancies had Ms. Madonsela afforded me an opportunity to present my side of the story or to get clarification from her. Thank you, Chair.
Over to you, Advocate.
Are you done, Mr. Molefe?
Yes, I am done, sir.
Okay. If you want to finish the conversation between yourself and your counsel, you can do that because I'm not going to allow the interaction once we start interacting. If there's anything that you want to sort out, you can finalize now.
By saying you will not allow interaction, does it mean I cannot confer with him when I'm asked a question?
Unless, of course, it is a matter of a legal nature, but you can't, on a factual issue, confer with counsel.
If
Is that been clarified?
If you insist, sir.
No. You've had a discussion or a conferral with counsel. Has this issue been clarified?
Yes, I hear what you're saying.
Let's start with, firstly, I want to thank you. I think it's a point to make from myself that when the committee invited you, you didn't get sick, you didn't proffer any resistance to come to the committee. And you furnished us with a statement that you've gone through with annexures. I think that's helpful for the committee, and I personally am grateful for that. I note, I might have missed it in your statement, and please help me understand. It's a very detailed statement with detailed annexures. But I missed your exiting media statement. Is it in the document that you've included in your statement? Not that you were obliged.
No, I did not include it because the exiting media statement was not the formal document by which I exited Eskom. The formal document by which I left Eskom to go on retirement was the letter that I wrote to Dr. Ngubane. So the media statement was something that I wrote, and but it is not a statement that I think would go to my personnel file at Eskom. What would have gone to my personnel file, and the treatment of my retirement would be treated in line with the formal letter that I wrote to the board when I was exiting Eskom. So I did not think, although it is something that I did not think that it was relevant to the formalities of my exiting.
When you left Transnet, what was the form of you exiting Transnet? Was it by resignation or was it by early retirement?
I resigned.
So you went to Transnet having made a decision that you'd secured employment somewhere, you're leaving Eskom. Transnet.
Yes, having been persuaded.
And that it was your unilateral decision. You did not need permission from Transnet to grant you permission to leave Transnet.
No, I did not.
The reason for that, you are correct, is because a resignation is a unilateral act by an employee. In other words, you do not need the employer to give you permission to leave. You can confer with counsel on that legal submission.
Yes, it is. I'm advised that it is unilateral to the extent that it becomes accepted.
But you made a decision, you communicated it to Eskom, to Transnet, and you went away to Eskom. The early retirement is different from the resignation because you need to source consent from the employer. Your leaving is not only at your discretion. Is that your understanding?
Yes, that is correct.
And that is why you would then have addressed a letter to Eskom asking for permission to retire early.
Yes.
But let's go back to your press or media statement. I don't know what they call them. I'm not a media person. But I do have it here. I don't know if you still recall it.
Yes, I have it. I recall it.
Do you want me to give it to you to read for the record?
No, that is not necessary.
Let me read it then for the record.
Yes, sir.
It is dated the 11th of November, 2016. And it says, on Wednesday, 2 November 2016, a report entitled State of Capture, prepared by the former public protector, Advocate Thuli Madonsela, was released. The report did not make any findings. Instead, it made what were termed observations. Based, the report acknowledged, on an investigation not completed. It deferred a proper investigation to a commission of inquiry to be established at a future date. The outgoing public protector has directed the president, in whom the Constitution vests the power to appoint commissions of inquiry, to appoint one, and further directed the Chief Justice to designate a particular judge to hear it. It is a matter for regret that the report was prepared in haste to meet a deadline related to the public protector's own departure from office. That office continues, as all state offices do, and that any uncompleted function is completed by a successor in that office was not a consideration in the report. In inverted commas, observations made in the report relating to inter alia my conduct are in material respects inaccurate, based on part facts, or simply unfounded. What the previous public protector has done is not herself to investigate to completion or to allow her office to complete what she initiated too late to complete herself. She has also determined on recording quote-unquote observations without, in crucial respects, putting intended harmful disclosures to me first, as she was by law required to do so. She has effectively deferred my constitutional right to be heard to a future date and to a further body, which she has ordered others to assemble. If such a body is indeed by law to be assembled and carry out the task, it will not be for some time, as recent experience indicates. In the meanwhile, harm is done to the institution. It has been my honor to lead in the most difficult times, to its reputation, to my own. I say nothing of the harm to others close to me. I am confident that when the time comes, I will be able to show that I have done nothing wrong, that my name will be cleared. I shall dictate myself to showing that an injustice has been done by the precipitated delivery of observations in inverted commas, following an incomplete investigation, which the former public protector has drawn back from calling in inverted commas findings. The truth will, I thought you say the truth will come out. That's what you want to know. I have, in the interest of good corporate governance, decided to leave my employ at Eskom from 1 January 2017. I do so voluntarily. Indeed, I wish to pay tribute to the unfailing support I have had since I took office from the chairman, the board, and with those with whom it has been my privilege to work. Together we brought Eskom from the brink. I will take time off to reflect before I decide on my next career move. I wish to reiterate that this act is not an admission of wrongdoing on my part. It is rather what I feel to be the correct thing to do so in the interest of the company and good corporate governance. I wish to thank the shareholder representative, Ms. Lynn Brown, the board, the executive team, and all Eskom employees for their hard work and guidance in steering the company out of the very difficult times during the 20 months that I was privileged to be a group chief executive. I go now because it is in the interest of Eskom. It is in the interest of Eskom, the public it serves, that I do so. Brian Molefe, dated 11 November 2016. Anything said in this statement that is attributed to yourself, do you associate yourself with it?
I associate myself entirely with that statement.
The reading of this statement makes it clear that you are just want to go back to the relevant paragraph. You say you've decided to leave your employ at Eskom. That sounds a unilateral decision. Would you agree?
Mr. Vanara, I don't know if you are trying to say that that statement was a letter of resignation. And if I had not done anything but write that statement, if my employment at Eskom would have terminated. I'm not sure. I mean, maybe this is a matter that will be determined by the court next week. But if I had written a statement like that and put it in the public domain, I don't know if that would jolt the Eskom HR department and the EPPF to suddenly start paying my resignation benefits because of that public statement.
We're coming to the pension, not so fast.
No, I wasn't talking about the pension. I was just saying, I don't know if you are trying to say that that was a resignation letter.
You have eloquently
And those are live visions coming from the Parliamentary Portfolio Committee on Public Enterprise, and with former CEO of Eskom Brian Molefe testifying, giving his side of the story. As you will know, this inquiry is also based on the State of Capture report, where Mr. Brian Molefe is implicated. The issues around how the Tegeta received the prepayment and other issues as well. Of course, his pension coming under the spotlight. We'll just exit this particular discussion for a little bit and hopefully get back to it as it develops.
And it forms part and parcel of assisting us.